Hello everyone and welcome to the Activist Lawyer podcast. My name is Sarah Henry and I'm your host to this podcast, which offers a platform for lawyers to share their story and their journey into law and activism. Our guests will discuss the challenges and highlights of their work, as well as important cases, opinions on legal and political matters, and will offer up advice and tips for anyone interested in pursuing a career in human rights law, public interest law, or criminal justice. The Activist Lawyer podcast is brought to you by the Granite Podcast Studio. Thank you so much for listening. Today's episode is truly inspiring. I'm privileged to talk to Dr S Chelvan, who I admire both for his work on specific areas of immigration and asylum law, and as a passionate, committed activist, academic and legal commentator. By way of background, our guest today is a multi-award-winning queer person of colour, first-generation Jaffna Tamil immigrant who lives with a disability and is self-identified as an activist lawyer. He is head of immigration and public law at 33 Bedford Row Chambers and Adjunct Professor at Southampton Law School. He's globally recognised as a legal expert on refugee and human rights claims based on sexual and gender identity and expression. Having practised in the field of queer refugee law since 2001, he has spearheaded strategic litigation in cases in the UK up to and including the Supreme Court and the European Court of Human Rights. Chelvan is specifically renowned to adopt a symbiotic approach to spearhead litigation, academic research and policy development in refugee and migration law. The past 6 months have included the judgment of the Strasbourg Court in MI v Switzerland, an honorary doctorate by the Open University, and profiled as the Times Lawyer of the Week. He adheres to being the mouthpiece for those who know the words but have no voice, knowing as an activist lawyer you will be driven by seeking justice for others, not for yourself. So it's, as I said, an honour to speak with Chelvan today. And there's lots in this episode, and for anybody interested in his cases, we do go into detail around those. I will share links to the cases in our show notes, and I really hope you enjoy today's episode as much as I did speaking with our guest. Dr. Chelvan, thank you for joining me.
Good morning, Sarah. Thank you for inviting me.
Not at all. I've been fascinated by your work, and again, very excited to have you join me as a guest to talk about your work, particularly given that I'm from an immigration law and human rights background. But before we get to some of that, I'm eager to find out how you got into law in the first place, and a little bit more about your background to becoming a barrister.
Right. Well, my full name is Dr S Chelvan. So I always used to have explained the S stands for the first letter of my father's last name. My given name is my last name, so everybody calls me Chelvan, because that sort of gives me a sort of way forward in relation to who I am as a person. I self-identify as queer. My pronouns are he and him. I'm a person of colour. I'm a first-generation Jaffna Tamil immigrant. I live with a disability, and I self-identify as an activist lawyer. And for me, my journey into law is a journey of self-empowerment, a journey of selfish realization that when I was at university, and I'm 50 years old in the last year, is that in the early 90s there wasn't an equal age of consent. There was discrimination in relation to the armed forces. There was no such thing as equal marriage, let alone civil partnership. You could actually be sacked in the workplace for being queer, for being lesbian, gay, bisexual. But for me, my visibility as a person of colour didn't allow me to mask who I was in any event in relation to being able to face discrimination and prejudice. So for me, the law was a vehicle to empower myself. And if I was able to use it to empower others, that was an amazing byproduct. But I wasn't born in the country. I was born in Sri Lanka. I came to the UK when I was 4 years old. So I am an immigrant. I'm very proud to say that I am an immigrant. But in the late 70s in Sri Lanka, where I was born, there was discrimination and persecution towards Tamils. And my mother was already here in the UK as an anaesthetist. And we were able to piggyback her visa to come to the UK. So we were in effect quasi-refugees. We were anti-Tamil rights in Colombia in 77, 78. And my parents decided it would be far safer to bring us to the UK. But we weren't refugees. We didn't know about claiming asylum. But that refugee story is very much ingrained into my history, because by 1983, when there was July riots in Colombo, there were massive waves of refugee population of Tamils all around the world. And my family in Sri Lanka were dispersed to Australia, America, Canada, all around the world because of our fear of persecution of who we were. So I always knew that my difference marked me out in relation to my history, my cultural, religious, social history. And therefore, in the late 70s, early 80s, there was the National Front, there was Enoch Powell, the Rivers of Blood. I remember my parents, for some odd reason, changing the channel when the sort of racist rhetoric came onto TV. But at age 14, I also realized I was different in a different way, that I was actually attracted to people of my own sex. So my narrative of difference was not only just in relation to the color of my skin, but also my sexual identity. And coming from a medical family, my mother's a doctor, and the issue was, I'd go into medicine. That's what I was expected. I was also expected to marry a Tamil girl and carry on the family tradition. But then my mother said, when it came to a careers guidance, a careers sort of worker experience opportunity, she said, look, do something else. So I went to Worthing Law Courts and worked shadowed the class, and I went to the courtroom, and it was a rather sort of, not a very fascinating case. It was a road traffic case, but the way the barrister was able to perform, to be able to control the courtroom, to be a storyteller, to the judge, fascinated me. And I went home and told my parents, I'm going to become a barrister, not a doctor. And my parents were like, no, don't worry, you can become a doctor and then become a barrister, and trying to explain that to my careers advisor. But for me, I realized that the law was my way of empowering myself. And for me, it was about a journey, because I always believe that phrase, life is a journey, not a destination. And to empower myself by using the law in that sort of area where, because of my sexuality, because of my race, that the law would actually be used to discriminate against me. I found various experiences. So, for example, at Southampton, when I was an undergraduate, there was we tried to do a ban on the armed forces, because at that time, you couldn't be openly gay or lesbian and serve in the armed forces. And I remember being a student activist, and I went to University Senate and Council and Court, and there was a policy in relation to the engineering faculty, which got funds from the armed forces. And we had an equal opportunities policy saying that you couldn't discriminate. And one of the grounds for non-discrimination was sexual orientation. And I remember presenting a paper on behalf of the Students' Union saying, look, the engineering faculty gets money from the armed forces. That is clearly in contravention of the equal opportunities policy. And I remember John Lowrise, who was the secretary of the University Council, saying the discrimination is lawful. And for me, that was the reason why I needed to get into the law, to be able to fight the discrimination which was lawful. So that is sort of a very convoluted sort of journey of why I went to the law from a very selfish viewpoint, to say that this is discrimination I face, and how do I change it? And I read politics and law at Southampton. And that sort of thing about, the citizen active or the citizen as passive. And for me, if you want to change your world, you have to be part of that change. Sure. So that's why I went to the law and went to the bar.
Wow. Well, thank you for sharing your story with us. And I'm very glad you did, because your cases really focus on that point of discrimination. Before we get into some of your work, I'd like to maybe just delve into your daily life as a barrister. And I know you're also an academic and a legal commentator. What's life like at 33 Bedford Row Chambers?
Well, I joined 33 in November 2020. I'm head of immigration and public law. We have over, 120 members of chambers, not just only in London, but also in York, in Sheffield, in Chepstow, and also in Antigua. And the wonderful thing is that we're a broad spectrum of, experiences and expertise in family, crime, public law, immigration, commercial, and arbitration. And the wonderful thing about my practice is, I was called to the bar in October 99 by Inner Temple. I was given a major scholarship there. And the wonderful thing is I'm able to mix my career in litigation as a barrister with my academic research and my role as an Adjunct Professor at Southampton at the Centre of International Law and Globalisation. And I also do a lot of policy development. And, when I was thinking about preparing for this podcast, unfortunately Tuesday night, Lord Etherton, who was first Chancellor of the High Court, and then, of course, Master of the Rolls, he passed away on Tuesday night. And in February 2013, Lord Etherton chaired my Stonewall lecture. And that's the first time I met him. And he was an out gay man who lived his life openly and freely. And at that time, the Home Office were dealing with lesbian and gay claims where lesbian and gay people had to prove their sexual identity. And it got to such an extreme that lesbian and gay people were sending videos and photographs of them actually engaging in sex to try and prove that they were lesbian, gay, or bisexual. And I use that Stonewall lecture to highlight that atrocity, that we've got to a society where to be able to prove who we are, they went to such extremes. And Lord Etherton was very kind and said, that a tour de force in relation to my lecture for Stonewall that year. And then many years later, after I joined 33, he approached me in relation to support and advice in relation to the litigation, the Nationality Borders Bill, which was the Nationality Border Act now 2022, the Illegal Migration Bill, and then the Rwanda Bill. And through that role, I learned very much how Parliament works. And he was very kind to invite me to listen to the debates and even sort of redraft passages of the sort of amendments to the bill. And it really showed me how Parliament worked. But it goes to the point that, I'm now living my dream, where I'm not only being able to litigate cases in the courtroom, but also advise in relation to how legislation goes through Parliament. I'm able to, for example, last November, the 12th of November 2024, I'm a person who thinks in footnotes, in dates, is that was a date, the morning that the European Court of Human Rights handed down the judgment in MI in Switzerland. I'm sure we'll speak about that case in a few moments, but I went from downloading the judgment with my legal team in Chambers that morning, then walking over to the upper tribunal within the hour and citing the case. And then the following Monday, teaching about the case to my LLM students at Southampton. And then within a month, referring to the case when I was awarded an honorary doctorate by Open University. And then within another month, being profiled by the Times as Lawyer of the Week for my role in MI as lead counsel for the interveners. So to say that I'm being able to bring in the strands of my work and my life together would be an understatement. So, I'm in a very, very happy place.
Brilliant. I'm delighted. With your casework, you mentioned there as well, proof and evidence, that's placed on a lot of the clients that you would have worked on who were perhaps claiming asylum based on sexual identity. And that's a theme that's exposed throughout a lot of the litigation that you've worked on. For people who aren't familiar with these type of cases, it's really breathtaking, the tests that have been applied by either the Home Office in the UK or other governments around the world that obviously have to be challenged at higher levels. But it's extraordinary. And even as a younger lawyer, I remember myself being before the Office of the Refugee Applications Commissioner in Dublin and hearing even the language used to a client who had to basically go out of their way to prove that they were gay and to give evidence of their sexual identity. And it's really quite specific in terms of asylum. So maybe we could talk a little bit about, you could take us through some of your cases that really kind of expose these tests, the discretion test and, all of this to the point where you mentioned there the case that you worked on in Strasbourg.
Okay, well, do we have 3 hours?
I know. Maybe 1 or 2.
I'll summarize. Okay, so we got the 1951 Refugee Convention. In 1999, the House of Lords in a case called Sharon Islam was the first landmark judgment which actually said that women stand alone as a specific convention reason within a particular social group to be able to afford refugee protection. And what I call the obiter breadcrumbs of the judicial table, Lord Steyn also said, well, homosexuals could also have that immutable and innate characteristic. So what happened was, as I said, I started my career in 1999. I was in pupillage at Doughty Street and then Garland Court. But during my pupillage, I was awarded a Kennedy Memorial Trust scholarship to go to Harvard to do my LLM. So I came back in August 2001. And at that time, there was a case called Jane in 1999, which provided a continuum Lord Justice Shaman said, there's a continuing where's the enforcement of criminal laws against gay people. I mean, it's talking about men. There was no reference to women. It's very male focused and dominated. And what I saw within the case law is that it was all about sex. Now, I'm speaking to you in my living room here in my home in King's Cross, and I walk out of that door, and as a gay man, when I walk out of that door, go to work, my life is not about sex. Yeah. It's about mundane things like going to work and talking to my colleagues or my friends about what I did over, the weekend, or talking, just sort of paying the mortgage or, paying the bills, etc. And I thought, if gay lives are all reduced to the function of whether they'll be caught, for example, in Iranian cases, there's a real risk of execution. And then you have the religious police, the Basiji. And the question is, will the Basiji find you in bed with your boyfriend, and therefore you put you to the, detention and torture processes and leading to execution? So I thought, well, wait a minute here. We should talk about identity, what it means to be a human being, talk about the expression, the conversation. The example I give is, on Monday morning, Laura in Kampala, in Uganda, is at work. She goes to the water cooler, for a break, gets some water, speaks to Mary, her friend, and Mary says, "What did you do over the weekend?" And if Laura says, "Well, actually, I met this really nice young woman called Jane, and we went for a picnic," I'm using ridiculous names here, but just giving an example. Yeah. Let's say they're overheard having that conversation in Uganda by Stuart, who's in the office. Now, overhearing that conversation may lead for her to be identified as a lesbian and therefore be at risk of serious harm. Mm-hmm. So there's no sexual act. It's just the actual conversation, overhearing the conversation, which could lead to risk. So what happened was in 2004, in a case called Z in November in the Court of Appeal, Lord Justice Buxton, LJ, was a case in Australia called S395 and S396, two gay men from Bangladesh. And within that judgment in relation to intensity and duration, they talked about discretion, that whether discretion would enable an individual to be granted or not be granted asylum. And there's a passage by McHugh and Kirby, the justices of the High Court of Australia, which is their version of the Supreme Court. And the Court of Appeal interpreted that test as saying, well, so if I point a gun towards you, would you run towards the gun or away from the gun?
Away.
Towards away, that's the question. Away, exactly. So just like if an individual is faced with persecution, they would conceal their identity, the majority, rather than identify, to run towards the gun. There will be the exceptions. For example, the case of SW Jamaica in June 2011, my lesbian from Jamaica, where the judges accepted that the genie had escaped from the bottle, even though there's a real risk of curative rape or murder in Jamaica. If you're a lesbian or perceived to be a lesbian, my client would be open on return to Jamaica. So what they said is that, well, if you, even in countries such as, let's say, I gave Iran or Jamaica, where there is a real risk of persecution, if an individual conceals their sexual identity, then they have to prove that concealment, that discretion, is not reasonably tolerable. So you have a canon of case law, 5 cases from 2004 to 2010 up to Supreme Court judgment. And in my first case as sole junior in the Court of Appeal in January 2006, a case called RG Colombia. RG was a gay man from Colombia. It's accepted that vigilante death squads in Colombia target gay men, prostitutes, trans people, and murder them. But for RG, for 13 years before he came to the UK, he was discreet. He hadn't been discovered by the vigilante death squads. And what the tribunals below held was that, he can go back and be discreet, and that would not be unlawful. So we were going to send back RG to Colombia for the rest of his life, where he would conceal his sexual identity as he'd done before. And in that case, there was a medical report by Dr. David Bell, which said that, if he tried to conceal his sexual identity, that would cause, in effect, mental breakdown. And Lord Justice Buxton said, well, that was pleaded within the Article 3 claim rather than the refugee claim. So therefore, it would be inappropriate to remit for that to be considered. So there was medical evidence that if RG went back to Colombia, he'd have a mental breakdown. Yeah. But even then, that didn't fit in the test of reasonable tolerable, because that was argued in the Article 3 case rather than the refugee case. And so that was the threshold. Even with a mental breakdown, an individual could be sent back to their return. There were other cases, Mari, lesbians from Ethiopia, then XY, Iran, and then a case of J. J was a gay man from Iran. We call it the barbecues in the back garden case, because he used to have barbecues in his back garden with gay friends of his. Few gay friends knew that he was gay. But of course, if the authorities found out that he was gay, there was a real risk of execution. That's been the case law in the UK since 2005, a case called RMBB. So the upper tribunal said that, he could be returned back to Iran. Then in the summer of 2008, I was contacted by an individual at the UK Lesbian and Gay Immigration Group. I was a trustee of UCLIG from 2005 to 2012. And he said, there's this gay Cameroonian who's currently, was locked up in Dungarvale in Scotland. And he's been told that, he can go back to Cameroon. Because what happened with HT is that he's a 40-year-old man in Cameroon. He owns a very successful carpentry business. It's a nice, warm summer's night. It's 2007. He goes out from his back door into his back garden with his boyfriend. It's a beautiful the moon is shining, the stars, yeah? He's there with his boyfriend. He leans over and kisses his boyfriend. But unfortunately for HT, his nosy neighbor sees him kissing his boyfriend. The following day, there's sort of insults which are thrown at him. Now, Cameroon is a Roman Catholic country. Mm-hmm. On a Sunday, he comes back from Mass, and the mob descend on him, saying, HT, you're a homosexual. All these sort of, then stones are thrown at him. Then the mob with sticks beat him to the ground. They beat him to the ground, using all sorts of derogatory, homophobic language. Yeah. The police arrive. The police say, well, what's going on here? Oh, HT's a homosexual. So they join in his beating. HT then hospitalized, goes into a hospital which has Jesuit priests, and they say, look, HT, you can't go back to your home. Yeah? We need to get you out of Cameroon. So they arrange passage for him from Cameroon to Canada. Now, unfortunately for HT, there's no direct flights from Cameroon to Canada. He has to go through this wonderful little island across off the coast of Europe called the United Kingdom. So he arrives in London, takes some few days a break in London, and then tries to get his flight to Montreal. But of course, before boarding his flight to Montreal, the immigration officers realize that his passport is a false passport. So he's arrested and detained. He's prosecuted, and he is sentenced for 12 months for using a false passport. He finds himself in Scotland and claims asylum. And then he goes to the Glasgow Tribunal. The Glasgow Tribunal accepts all the evidence in relation to his narrative. He's got medical evidence regarding a perforated eardrum, the scars, the wounds all around him. And what they say, we accept that you're gay. We accept that the mob, targeted you and beat you as you did. But it was your fault. If you hadn't gone into your back garden and kissed your boyfriend, then nobody would have known that you were gay. So we will say that we accept that you're gay. We accept that you can't go back to your home area, but you can live in another part of Cameroon, and that will be reasonably tolerable. There'd be no issue with that. And ironically, the Home Office presenting officer in Glasgow actually used the case of F in UK in 2004. Remember, this is 2008 by 2007, 2008 by now. So, the country guidance case of RMBB said that, Iran is bad for gay men, they will suffer execution. But they were using the case of F in UK in 2004 in the Strasbourg court, which basically said, look, it's, you can expel somebody to Iran. And they say, look, Iran's like Cameroon, so everything's fine. Now, that went to the AIT as it then was. And luckily for me, the judge, whilst the lawyers were in Glasgow, the judge was in London. There's a jurisdiction issue there, which we'll come to in a few moments. And the AIT judge also accepted, it was his fault for not being discreet enough, and therefore he can go back and go to Cameroon and live somewhere else. Now, the problem with that, of course, is that, when he was in Scotland, he was then transferred to UK immigration detention centre, and the Scottish lawyer says, look, we've no longer got jurisdiction. You have to go to English lawyers. And by that time, he was like, more than a couple of months out of time in relation to an application to the Court of Appeal. I just got permission to appeal to the Court of Appeal in a case called AM Syria, which is on the same point of the reasonable tolerability discretion test. H.J. Iran had also got permission to appeal to the Court of Appeal. And I was thinking, well, let me try and see if this case can also go to the Court of Appeal and tie in. Because this is a case where we've got somebody who's, unlike H.J. Iran, who wasn't targeted by the Iranian authorities, I got somebody who was not only targeted by the mob in Cameroon, but also the police joined in his persecution. Yeah. We got somebody who's actually targeted. Yeah. Mm-hmm. So in front of Lord Justice Rick's permission out of time in relation to the fact that, how can we say that discretion will be reasonably tolerable for an individual who's actually suffered persecution because of his sexual identity? There was a jurisdiction issue because, of course, the first instance tribunal was in Glasgow, first year tribunal. So then the question is whether it's to the Scottish Appellate Authority or through the English Appellate Authority. And luckily, I was led by Raza Hussain in the jurisdiction hearing, and we were able to argue that because the judge was listening to the case in London, England and Wales had jurisdiction rather than Scotland. My Scottish colleagues aren't too happy about that, but that was the finding there. That went to the Court of Appeal in 2009, and one of the most homophobic judgments of the Court of Appeal, where the judges were adding a layer saying where the criminal laws prohibit same-sex consensual adult activity, then the gay and lesbian individual should, respect those laws, the cultural relativism test. And so it's trying to say the actual laws which give a rise to the persecution should be respected by lesbian, gay and bisexual people. Lord Justice Pill, paragraph 132 of the judgment. So in July 2010, noting that by that time, both Stonewall in No Going Back and UK LGIG in their Failing the Grade report found that 98 to 99% of lesbian, gay and bisexual claims were refused. Not on the fact that they couldn't prove that they're lesbian, gay, and bisexual, but because there's a reasonable tolerability test.
My goodness. Compared
to 73% of non-LGBT cases, that we found that, clearly this is being targeted in relation to that. We accept that you're gay, but, we'll send you back to countries where you'll be suffering persecution because you will be discreet. Yeah. Even though these individuals have traveled thousands of miles, it was in front of the tribunal claiming asylum, it would never be in their narrative. It'd be a negative fact-finding tribunal or a negative decision of the Home Office, which will say they will be discreet, and that'd be voluntarily discreet. That's the anathema in relation to that, because it's not voluntary. If you're facing the gun, that's not really voluntary. I mean, the Supreme Court know that. So in July 2010, noting that we had a new government, so the discretion test from November 2004 up to the end of May 2010 was a Labour government policy. There's a Labour government which introduced a discretion test through their lawyers in November 2004 in Z, and then, of course, RG Columbia, Amari, XY Iran, and then J. And then, of course, HA and HT in 2009 in February. Mm-hmm. So we thought, actually on the final day of the hearing before the Supreme Court, it was the Lib Dem and Conservative coalition. We all thought, I wasn't then instructed, but I was there assisting and saying, look, the Liberal Democrats have a policy against discretion. We were thinking that was going to be a change in the instructions to the Home Office regarding this, but there was no change in instructions. So by the time of the 7th of July 2010, the Supreme Court, 5 justices of the Supreme Court, all white, straight men, as far as we knew, so we were worried in relation to the judgment. But they said, look, no straight man would find, discretion reasonably tolerable. What sort of yardstick would we measure it by? But then in paragraph 82, Lord Roger, and this is the template for all protection, asylum and human rights claims since July 2010. So the first limb is prove that you are gay or perceived to be gay. So that's a subjective evidence. The second limb is, do openly gay people have a well-founded fear of persecution? And that's really important because, as we said, Sarah, is that the majority of people would run away from the gun. Yeah. So even if you have, let's say, 1 in 10 or 1% of the population. So, for example, in Iran, there's 84.1 million people in the population of Iran in the early 2020, 2021. So let's say 840,000 people in Iran are supposed to be lesbian, gay, or bisexual. Well, where are they? Yeah. They're not there because of the persecution. So the only people who would be in that openly category are those who are the activists or those who are identified because of their nonconformity. Yeah. So therefore, you look at the country evidence, see what happens to those open people. And we can call that the gay martyr principle in a few moments. So that's the objective evidence. And then limb 3, will the individual be open? And if the individual is open, then they're a refugee. And then the test is, but if they are only discreet because of personal choice or social pressure, they're not a refugee. So remember, these individuals travel thousands of miles. They're going through their appellant processes for years, and they're not going to tell the tribunal, by the way, if a gun is pointed towards me, the only reason why I'll be discreet is because mum and dad won't approve, or there'll be a few name calling. Yeah. Even though mum and dad may not approve, may lead to honor killing. There's a causative nexus there. But we as the United Kingdom say, look, those people will not be provided refugee status. In a case of mine called LC Albania, which entered the Court of Appeal in 2017-18, was one of those findings. But if a material reason for that discretion is because of a fear of persecution, then they are a refugee. So what happened after that is that in 2012, I was invited by UNHCR to sort of give some sort of training on a model I created in 2011. Because, of course, the first question is, well, how does an individual prove that they're gay? Now, you refer to not only tests in the United Kingdom, but also outside the United Kingdom. In 2008 and 2009, in the Czech and Slovak Republic, there were phallometry and vaginal. Sorry, I can never pronounce it properly, but basically what happened was an individual would be shown images of pornography, or same-sex pornography, but will have electrodes and all sorts of things inserted into their body or around their genitals to be able to measure sexual response and be able to show the photographs. Now, and this was actually started in a case where a lawyer on behalf of an Iranian gay asylum seeker in front of the Slovak authorities were trying to use this to prove that an individual was gay. These were the type of tests which were used in Europe, and the German administrative court later on actually stopped the removal to the Czechoslovak Republic because they said, look, the individual faced a real risk of Article 3 inhuman degrading treatment to be exposed to these sort of tests to prove their sexual identity. So in 2012, when I was at the round table, there were representatives from all different countries around the world, and clearly Chatham House rules, I can't identify the individual. But one individual said at one point, well, I know what normal is, so how do I prove that the individual is gay or lesbian? And very quickly realized that they should never have asked that question with me in the room, but they should never ask that question at all. Yeah. So the battleground then was how to prove that somebody is lesbian, gay, or bisexual. And in 2008, I started my PhD at King's. So I got a research PhD and an honorary PhD, but I started my research PhD about, because I was litigating cases through the England and Wales sort of tribunals and court of appeal, and saying, well, how does somebody prove that they're gay? So in 2011, I created a model called the DISH model, difference, stigma, shame, and harm. Is that the first question is not asked when somebody is lesbian or gay, because in a lot of countries, they don't use what we call positive identity markers. In Jamaica, a gay man is a batty man, a lesbian is a sodomite. These are not positive terms of endearment. The first question is, when did you realize you were different? Okay. Because within these societies, within even a sort of a mathematical sort of percentage, the majority of people are what they call straight or cisgender. So by being queer, being lesbian, gay, bisexual, transgender, by being a sodomite, being a batty man, you are different. And that difference is usually identified in childhood or youth. It's because of our non-gender conformity. The examples I used to give is that my little brother had for his 7th birthday, a sort of a football pitch, and then an R2-D2 for his 9th birthday, where for my 7th birthday, I had a cake with, pink roses and, green icing. And then for my 9th birthday with butterflies and roses. And, I never knew I was gay then. Yeah. My parents, for some reason, were totally accepting with that. But for me, it's gender nonconformity. Most of my friends were girls rather than boys. And you see that narrative, the devil's in the detail, that, from difference you have stigma, because, you're the individuals who's the group differentiated individuals. That's what social scientists refer to. And you realize that other people like me. Mm-hmm. And that's me at 14. But that stigma for religious, social, cultural, stigma for shame, providing that sort of nuances that, my late husband, used to hate going to church on Sundays because the priest of the pulpit would talk about Adam and Eve rather than Adam and Steve, that fixation with homosexuality. And, with that sort of narrative in relation to that provides internalized shame. That's not the shame about being gay. It's the shame about the stigma. Now, different stigma shame comes into the majority of gay narratives, even with those who are not refugees. And then what happens, of course, what makes the refugees the harm narrative, that the harm they'll be facing because of their difference. So I created the model in 2011, and I spoke about it in Laverne in April 2011 for the Eleanor conference. And then by 2012, I was speaking about it even more. Now, this is me as a lawyer referring to a model, and it's not a questionnaire. It's trigger questions to be able to enable the individual to be able to speak about their narrative. And then went to UNHCR. UNHCR endorsed the model in their international protection guidelines. You'll see that in one of the footnotes there, different stigma shame. And then what happened was, in the UK, a bisexual asylum seeker was asked by the immigration officer at Haslow Detention Centre, what attracts you about a man's backside? Did you wear a condom?
I read that.
All these sort of absolute outrageous questions. And that was reported in The Observer the following February, just before my Stonewall lecture. And Theresa May, who was then the Home Secretary, asked John Vine, the Independent Chief Inspector, to do an analysis about the approach to sexual orientation asylum claims in the UK. In England and Wales, and he and his group contacted me, and I spoke about the DISH model to them. And then one of their recommendations in the report by John Vine was that the Home Office started using this model as one way of establishing credibility. And in 2015, the Home Office started using the model. Now, various governments around the world, Sweden, Finland, Switzerland, Germany, New Zealand, around the world started using the model. UNHCR started using the model in all their global field training since 2015. And for me, I lose work by doing this because my solicitors use the model for their lesbian gay clients. And as I said, the devil's in the detail. For all my clients, they write their life stories. Absolutely. Yeah. And it gives them the ability to be able to define their emotional and physical journey to who they are. So since then, it went from, discretion to disbelief. That's the phrase used by Jenny Milbank, the academic in Australia, to see what happened in Australia after the S395 case. And now the major battleground is proving gay, but also understanding, one of the martyr principles, one of the things the Supreme Court referred to is that, unless the individual wanted to swell the ranks of the martyr, that's what Lord Roger referred to, is that the majority would be discreet. And Lord Walker and Lord Dyson, as Master Rolls, also referred about this martyr issue. Then we have to realize that when you're looking at the evidence, and this goes to MI in Switzerland, so I'm fast forwarding the cases a bit in November, is that one of the important things in the judgment of the European Court of Human Rights. Now, what's quite interesting is that one of the lead lawyers for MI, Dr. Stephanie Motz, was my pupil in February 2009 when I was junior counsel in HT Cameroon, and she ended up being one of the lead lawyers in MI, and I was instructed as lead counsel with Hayley Digital at 33 Bedford Row, instructed by Jackie McKenzie at lead A for the interveners, Stonewall and African Rainbow family. And they were looking at, the European Court of Human Rights were looking at the evidence of risk to gay men in Iran, and they realized that they looked at the data, and the only data set they looked at was within the Home Office 2022 report, which shows 79 executions of gay men between 2004 and 2020 under the sort of legislation. They may not have identified as gay, but, so there's 2004 to 2020, 79 executions. To 2021, 2 executions for those for forced sodomy, and 2022, 2 executions for forced sodomy there. So when we look at Iran, 2021, population of 84.1 million, 840,000 could come under the lesbian, gay, bisexual umbrella, or even less. But then it's only 79 executions over 16 years. It shows that we do not need to actually establish hundreds or thousands of incidents of persecution or harm. It's a very important issue in relation to how we look at actual evidence of persecution. But we can look at a very small number. As long as that number crosses the threshold to what constitutes persecution, then we've established the requisite threshold to establish a reasonable degree of likelihood of harm. So that was very important in relation to that case for me, but also very importantly, the whole narrative of MI regarding the family forcing him to get married and the discovery of photographs on his mobile phone were completely rejected by Swiss authorities. And they said he could just be discreet. They did not look at the real risk of harm to him. So looking at the 8J Iran principles, there was no finding that discretion was linked to a fear of persecution. And what the European Court of Human Rights said is that discretion reasoning should have no input in relation to establishing whether an individual will be at risk on return on Article 3 protection. So that judgment stopped discretion reasoning in any Article 3 protection claim. They said, looking at UNHCR guidelines, that discretion is not guaranteed. It cannot be lifelong. Yeah. And that's a clearly obvious conclusion. So the question is then, will those findings of the European Court of Human Rights now be used to displace discretionary reasoning? And that's one, I've been spending 14 years in strategic litigation to see whether that can be done. I can't say too much at this stage because of legal privilege, of course, but there are cases going in the courts at this stage which hopefully be able to pick up, and we will actually look, we should be concentrating on the two limbs, whether a person is gay or perceived to be gay, or, remember, those guidelines apply to all 5 convention reasons.
Yes.
So whether they are within the convention reason or perceived, imputed, and whether openly individuals within that convention reason have a well-founded fear of persecution. And that's how we should be pressing forward in relation to examining protection claims of any refugee who seeks sanctuary in the UK.
Thank you for that detail. It's excellent. And the fact that you have developed the model offers huge relief, to applicants, and that it's being so widely used is such an achievement. Just one wee point I wanted to just go back on. You've mentioned the two limbs there, but in terms of the reasonable tolerability test, the Supreme Court in HT Cameroon allowed the appeal in that case, and said that the test applied by the Court of Appeal in that awful damning judgment that you referred to was contrary to the convention. Where are we in terms of that test itself and the return?
No, that was struck down by the Supreme Court in 2010.
Yeah, that's it.
And then it was replaced by the 4 limbs by Lord Roger in paragraph 8. I mean, the case is famous because he says, it's called the Kylie concert case, and according to gay gossip before,
that's right.
Kylie, what's her name? It was called, Barbara Streisand, and then, some diva within the gay music world, and then it was changed to Kylie. But he said, just as straight men are able to drink beer, go to rugby, and talk about girls with their male mates, male homosexuals, a horrible term used, but male homosexuals should be able to drink exotically coloured cocktails, go to Kylie concerts, and talk about men with their female mates. Now, what he wasn't saying is that, the gay refugee seeking asylum is not going to be asked, what's the third track to the Aphrodite album? Sure. I mean, of course, all gay men love Kylie, but the fact that, we're all different. The issue is that we all have a right to live freely and openly without the fear of persecution. And ironically, just after the Supreme Court judgment, 2 gay men were actually arrested in a Cameroon bar for wearing tight T-shirts and drinking cocktails. That's reported in the Pink Press. But, it's very important to know that we should be able to live our lives as we wish to. The issue as a refugee lawyer, and, that's irrespective of, there's a canon of case law in the European Court of Human Rights, Chahal, Chahal specifically, and the European Court of Rights have been, very clear that even if you're a terrorist, the point is, Article 3 of the European Convention of Human Rights is a safety net which catches all and says there's an absolute guarantee that you will not face a real risk of torture, inhuman or degrading treatment or punishment. And as the Supreme Court said in the Rwanda judgment in November 2023, it's not just the European Convention of Human Rights. It's also the UN Convention Against Torture. It's also the International Civil and International Covenant of Civil and Political Rights. We also have the prohibition of torture in our common law. So we're not talking about foreign judges in foreign courts. It's part of the fabric, the framework which makes us a democratic nation which has checks and balances which ensure that we abide by certain core human rights principles. So that's, I remember being asked in the Court of Appeal in February this year, in a case called PG, in a case of PG is a convicted child sex offender, and Lord Justice Bean, as a presiding judge, said, well, Dr. Chelvan, does that mean that any child sex offender cannot be deported? I said, my lord, I'm a refugee lawyer. As a refugee lawyer, I look at future risk. And if the country background evidence shows that there's a real risk of torture and human degrading treatment on return to that individual, we as a nation do not deport, because that's an absolute guarantee of protection. Yeah. So, it's very, very important. My caseload is far more, narrow in relation to the cases I now litigate in the courts. But it's that one principle, that one universal principle which brings all of us lawyers together. Even Chris Phelps in the interview Radio 4 last week said, well, you can't get around Article 3. Yeah, he accepted that. Those were his words, or words around to that. And that's a central issue, is that you can't get around prohibition on torture.
Yeah, absolutely. Well, and that was a wonderful snapshot of some of your casework, because I know there's others that we could delve into. But just to see that progression, I'm really keen to see what comes out of some of the recent cases at European level as well. But are there any particular cases or moments in your career so far that stand out for you, for which you're particularly proud of, or which you're pleased to have worked on?
Well, I refer to African Rainbow Family, which was one of the interveners in the case in the European Court in Emma in Switzerland. And African Rainbow Family was founded by Adjunct Professor, a Nigerian lesbian activist. And I first met Adjunct many, many years ago and I was instructed as her counsel in the Court of Appeal. Now, Adjunct was one of those examples where in the High Court, she submitted a DVD of her having sex with her then girlfriend to try and prove that she was a lesbian. And I found this absolutely outrageous. And I represented her in the Court of Appeal. And there were 400,000 pages of extra material in this fresh claim. And the Court of Appeal were very good and said, look, clearly there's something in there. And, the Home Office have got to decide what to do about this case. Now, Dronky came to the UK in 2004. She couldn't come out as a lesbian. She referred to the fact that, what happened to her is that she married a Muslim man. She's a Christian, and she had a same-sex relationship with her girlfriend and was caught and was sentenced by the Sharia court to death by stoning. And her son was killed with her daughter living, and she escapes the UK. And she said everything about that narrative, but she used the religious persecution rather than the fact that they targeted her because she was a lesbian. And she spent 13 years, she was only later on that she came out, and she actually drafted her own grounds to stop her removal, because all the lawyers, even very famous legal aid lawyers, said that she had no chance and no grounds to resist deportation. And the judge granted her application because of her, she referred to her mental health and other issues in relation to why she could not be removed. So that was in 2012, 13, and then 2016, I appeared before the Court of Appeal and representing her. We went back to the first year tribunal. Sean McLaughlin at TRP Solicitors was her solicitor, amazing activist lawyer there as well. Mm-hmm. And, after various pre-hearings where we had, so many different witnesses to prove that she's a lesbian, the fact that her name was all over the internet with tens or hundreds of thousands of hits regarding her name. And the Home Office, in August 2017, conceded her case and said, you are a refugee. And I remember being outside of my chambers, the chambers, the number 5 chambers. And what I love about my work is clearly it's not the financial reward, because I the amount of money I could have got in earnings in commercial litigation or other areas of law after leaving Harvard were giant compared to working as a legal aid lawyer or pro bono lawyer for a lot of the work I do, is a thank you card. And the thank you card usually says something about thank you for saving my life. And that's priceless. My clients never forget me. And that was huge. After my husband passed away unexpectedly in March last year, all my clients were very much rallying around, and we may speak about that later. But Adjunct turned around to me and said, "Thank you for giving me my freedom."
Oh, wow.
And that said it all.
My goodness. Wow.
So that's an example of what drives my husband. So I had to deal with 5 bereavements. My mother passed away in September, then my father-in-law in January 2004, then to 24, and then my husband in March 2024, and one of our dogs, and a very close friend in November 2024. And Mark said, after my mother died, I asked him, why are you in love with me? And he said, because of your passion, intelligence and compassion. Because I restricted him to 3 words, and every single one of my refugee lawyers after he passed away said, the one thing which identifies you, Chelvan, in relation to your work is your passion, your drive. And I was thinking about giving it up because Mark was my rock, and everybody who knew me knew him. So for me, it was very much that this is my calling. That through empowering refugee clients, it's not my case, it's not your case, it's their case. By empowering refugee clients to being their storyteller, telling their story to the judge, and being their interpreter, interpreting their stories from the foreign language of the law, is my calling. Yeah. It's not a job.
It's not a job.
It's not a way of life, it's a vocation, it's a calling. And for me, I love the law, I love the intellectual engagement. I love the way, English legal education says A plus B equals C. At Harvard, it was very much like, you know where you want to go. Where's your outcome? What's your final answer? Where's your destination? And once you know what your final answer is, invent the formula. And that's what I've committed my career to, is by inventing the formula to getting to the answer we know should always be there. So, my Tamil Hindu mother used to say, God says 3 things when you ask God a question: yes, no, or later. And I've never been very lucky in the Court of Appeal. I've never succeeded in the Court of Appeal. And whenever they say no, I always say, well, it's actually, no, it's not. No, it's come back later.
Come back later, yeah.
And, I'm a strategic litigation lawyer through and through. And I feel sorry for my clients because sometimes I get a brief in the first year tribunal. I think, oh, that's a really good point to run in the Court of Appeal. I feel it's some sort of sickness. And, I have an amazing cohort of instructing solicitors who keep on having to address what I call my shopping list. But, they very much are committed to, the fact that for me, it's about not just one case, it's about shaping the law in a way which we fully protect those who are vulnerable. Yesterday we celebrated VE Day. What was VE Day all about? It was about ensuring that fascist regimes who targeted vulnerable and marginalized people will never have power and control again. And what we're seeing in countries around the world, in Western democracies, and the rise of political parties such as Reform or the far right and the Conservative parties, is the rise of neo-fascist nationalism, and we must stop that. And the great thing about the UK, and I say this in all my training in the UK and internationally, is that what is the sign of a true democracy? The sign of a true democracy is independent judges. That, my husband and my best friend Norm forbid me from ever going into politics because I'd get too angry. Yeah. But what I do is I go into a courtroom, I argue a case in front of an independent judge, and that case could not only impact on my client, but could impact on the future of the law. Yeah. And that is what we do. We must use the law to empower and protect individuals from the overarching control and power of the state, especially a state. I mean, we're seeing this with the current Labour government. We're seeing this with all things issues in relation to what's happening with immigration. The fact that next week we're expecting a paper which says that highly skilled workers would have to have basically the same level of English language as an A level. I know. To come in. Yeah, so these are construction workers and care home workers who would need the same. I mean, that clearly will have to come up to litigation. We're having issues in relation to the fact that if you arrive on a boat, the whole concept of illegal migrant only came through on Section 40 of the Nationality and Borders Act 2022. Yeah. Because the Home Office were losing cases in the courts where individuals who arrived on boats were in effect were able to rely on the fact that they came here legitimately to claim asylum either on the shores or shortly after there. So therefore they created any individual who comes to the UK without a visa is illegal. That created the narrative, because what happens is the courts say unlawful, Parliament legislates to make it lawful. That's not the type of democracy we should be about. So we criminalize all individuals who genuinely seek asylum. We know that nearly 80% of those individuals who come on boats are genuine refugees, either granted refugee status. That was a study by Refugee Council in relation to the narratives. But why are they arriving on boats? They're arriving on boats because when the last Labour government were in power, they arrived by Eurostar. They went to Waterloo. When we stopped that with checks, they went by lorries. When we stopped the lorries, they're coming by boats. What is the easiest way to smash the criminal gangs? The easiest way to smash criminal gangs who are forcing these individuals to arrive by boats is have an asylum registration centre in Calais or northern France. They'll be screened and then provided the journey to the UK by the UK government. That will cost far less than the hundreds of millions of pounds we provide to France or what we're trying to do in smashing the gangs. Easiest way to smash the gangs is stop the market, stop the demand.
Mm-hmm. Exactly.
Because up to September 2011, we had a policy, and it's still on the Home Office website, because September 2011, they had to issue a policy saying that the previous policy was no longer, where an individual could cross the border from the country of the nationality where they were fearing persecution, and then in the next neighbouring country, go to the British Embassy or the High Commission and then apply for asylum. Now, where are the statistics that was used fraudulently by bogus refugees? There are none. Yeah. So we had a policy where individuals could claim asylum in a country outside the country of nationality, which wasn't the UK, and come to the UK and claim asylum. Yeah. So all we need to do is think about common sense. We shouldn't be pandering to the right wing who will focus on, first of all, it's, migrants, refugees, course, then it's the trans community and non-binary individuals, and then it's you and me, Sarah. Yeah. Because that's exactly what happened in the 1930s. If we're going to learn anything from history, we should know quite clearly that they'll go to the most vulnerable and they'll come for you. Yeah. What
a grim.
Okay. So we really need to arm up. I mean, I've looked at some of your podcasts. We've got a wonderful wealth of activist lawyers, and I use that on my Twitter, what was then Twitter, now ex-bio, right after what Patel and Suella Braverman. I was actually in chambers with Suella Braverman in number 5 between 2011 to 2015 before she went to Parliament. So you get to an age where you actually know these individuals,
really,
who then have power. But clearly, we respected each other on a personal and professional basis while we were in chambers. But the point being here is that, people should no longer be scared, because those of us who hold these values, these common values, these common decency values, these moral values which fight against the evil and the poison of the far right who want to harm individuals, is that we should be able to stand up and be counted and speak with one voice. But, you and I, too scared to put a comment on Twitter or any social media because of the viral storm in relation to the reaction by individuals who have far more time on their hands than you and I do to be able to target us. But what we have to do is use our soft power. So for your listeners who are thinking about a career in human rights, is that use your soft power, because I love that, phrase by, Thomas Hobbes, knowledge is power. That's the one thing. I've got into the room because of my expertise, because of my soft power. I was, one thing which we haven't kicked out, I got kicked out of home for when I came out as gay at 21. I was left with nothing. I had 18 dustbin bags and 19 cardboard boxes and a letter from my mother's solicitor saying that I was disowned and disinherited until I recanted my behavior and practices. So, when I talk about Harvard and my PhDs, these are all things which I was awarded, and because I had people, my chosen family, Absalom Morgan talks about chosen family, who believe in who I am and what I did. And, they very much believed that, I could, change the world. I mean, Caroline Thomas, my personal tutor in politics, whenever I felt down, she said, you got so much more to give. That's one of the things in the bio I wrote, is that, as the activist lawyer, remember that you are there to seek justice for others, not for yourself. And so having come into the profession thinking it could empower me, actually I'm now, as a strategic litigation human rights activist lawyer, driven to empower others, not myself. Wow. And I think, and then leading to my clients basically saying, thank you for giving me my freedom.
Yeah, I think it's so refreshing to see you described as an activist lawyer. And as you say, collectively, we should all feel empowered, particularly as lawyers, in standing up to what's happening across Europe and indeed further afield. You touched on working in this area, and I'm wondering if you could perhaps share with our listeners who might be interested in this specific area or in becoming a barrister, in terms of getting involved in your type of work. I mean, immigration law, it's not an easy area to work in, and I'm wondering if you could share some tips with our listeners.
Well, I say to anybody who's going for an interview or, trying to go to, identify your USP. What's your unique selling point? So when 20 years ago, when I applied for pupillage, I said it's a black gay man with a hearing impairment. I understand what it really means for civil liberties. I was saying, I'm not here as an academic, I'm somebody who's actually got lived experience. And then, when I went for my interview with the Kennedy Scholarship, I said, I want to be the mouthpiece for those who know the words but have no voice, to be an advocate. So find out what your USP is. Not like I really enjoy being in the library reading contract law, so I'm just giving some example. A lot of people refer to, I like doing death penalty work. I mean, that was the big thing when I was applying for pupillage. Everybody did amicus in text, and I thought, you've got to find something else. Clearly, people who are very much committed to death penalty work should be doing amicus work. But for me, identify your USP. What really drives you? What's your passion? Why does your heart beat in the way it does? I always believe that. I always believe, hold your head up high and listen to your heart. I very much believe that in life, both in the professional and the personal. So, what I'd advise you, identify your USP. Take time to identify your USP. And then when you've identified your USP, find the interpersonal skills which are able to prove, the advocacy, the opinion writing, the teamwork, the leadership, and go think out of the box. So, for example, after I came out to my family, I basically ended up being on TV. I was on, Esther Ranson's program twice and other TV programs talking about what happened to me at home. So for me, my advocacy was, being on TV. I know a lot of, not of course, in present company, of course, but, a lot of, I'm finding, so many invitations to go onto podcasts by people who are going through the pupillage process because it's something they find as different. So I think that's been done to the hilt. So find something different, something unique, because, you're going to have to jump out of that paper.
Sure.
Yeah. And I'm very much about finding the niche area. For me, I knew I wanted, as I said, I've been working in LGBT science since 2001 when I was a pupil. Yeah. So, don't be scared about that niche. Chambers will make sure that you have your second bow to your string. Sure. Yeah. We will make sure, for example, when I was, a pupil and a squatter, it's very much, my age debt was, nearly £40,000, the amount of money I was owed by, in legal aid cases by, which was not paid. And that should not be the way of, the life of a pupil or a junior tenant. So, Chambers, for example, they'll give you PI work, which will ensure you get a steady stream of income to be able to pay your rent, or if you're lucky, a mortgage. But don't be scared of that. And I would say get a master's.
Okay. Yeah.
It's 1 year of his life. I was speaking to a very, very good friend of mine's son at, my friend's 50th birthday last week. He said, "Oh yeah, but it's another year." And I said, "You're in your 20s.
I wish I did it.
Is nothing. Yeah, a year is nothing.
Yeah.
Seriously, you look back, because when I got people like Daphne in Garden Court, especially, I was there in Garden Court and none of us had masters. And I went to, I first of all did a visiting research fellowship at Northwestern University in Chicago, and then I did my master's at Harvard, and I came back and all of us had masters who were second sixes there. So, and this was 1990, so this was 2001. Yeah. So, do that specialist masters. And then, I did a PhD part-time when I was, a junior barrister. And nothing beats a PhD because it gives you that ability to be able to think about things from a completely different perspective. It's not the two-dimensional, it's a three-dimensional. It's you're looking at a problem from above, below, beyond, So for me, but that's, me being I never want to stop learning. I used to joke that the day I stopped learning is the day my husband lights my funeral pyre. But, because never, if you want to be a lawyer, whatever lawyer you want to be, never stop wanting to learn. Yeah. And that's a real passion about the law, is that you're continually learning. And go on social media platforms, go on LinkedIn, go on, even X, even Blue Sky, to be able to read, because I learned so much. I was saying to a junior colleague of mine last night in the early hours when I was helping him draft a document for a case this morning, I said, look, I saw this case on LinkedIn, and I immediately, what I do is, read that case on LinkedIn, and I automatically email it to myself with a subheading about what that case is. And then my memory reminds me about that case, because that's what will mark you out from your opponent. Because, always apply cases which support you and distinguish it on the facts cases which don't support you. So, it's that skill of, learn, think in footnotes,
sure.
Remember the key issue in a case, which really sort of turns a case which you can distinguish. Believe in your passion, your intelligence, and your compassion.
Look, Chelvan, your work is so impactful and crucial. I urge anybody to even go onto your Chambers website, and there's links to some of the cases that we discussed today, which are truly remarkable. And your passion is just infectious. So I want to thank you for your work, for what you've contributed to this area of the law, and also for talking to me and sharing your thoughts and your journey with our listeners today. It's been truly, truly inspiring.
Thank you, Sarah.
Thanks everyone for joining me today. If you like the show, please remember to share and leave a review if you have a moment. And you can also check out our website, www.activistlawyer.com, where you will see some blog articles written by our guests and contributors, as well as some fabulous Activist Lawyer merchandise.
This podcast was recorded in Granite Podcast Studio. Interested in starting up your own podcast but don't know how? Granite Podcast Studio can help. Record your podcast in our state-of-the-art studio, which is based in the heart of Newry City. Our studio has cutting-edge and user-friendly technology and can seat up to 4 people. We also provide an editing service for our team, using your guidance and editing notes to provide you with a flawless finished product, leaving your listeners wanting more. For more information on how you can get started, visit www.granitepodcaststudio.com.